Steve, as you know, UNUM professes to be the world's largest long-term disability insurance carrier in the world. And one of the issues I want to discuss with you today is what should a claimant expect after they've exhausted all their administrative remedies on an ERISA lawsuit, and their only remaining option now is to file a lawsuit. So I want to go through some topics like what are the time frames that a claimant should expect, what are the challenges that they should expect, and we'll go into some other topics going through that, considering the fact that we've handled hundreds and hundreds of claims against UNUM. So let's start with, after the appeal has been denied, what's the option for a claimant?
Well, after it's denied, your only option at that point is to file, a lawsuit in federal court. That's the next legal step. When you said with time framing, one of the big things it would be, because we do get calls on it, is your policy is going to have a statute of limitations, which is a set amount of time that you have to file a lawsuit within. If you wait beyond that point, then you'd be barred from bringing the lawsuit. So considering that there's no issue with that statute of limitations, then your option is the filing of a lawsuit. And the time frame of that can really vary quite a bit, depending on the court. Certain judges will, you may be tied up waiting for a decision on a quote-unquote trial for, 18 months to 2 years. It may be resolved earlier than that by way of mediation. So it can vary, but you could realistically expect it. It may be a 2-year, maybe even more process if there's appeals, to a higher court after that.
Okay, now in terms of the filing of the lawsuit, we represent claimants all over the country, and since these are ERISA cases governed by federal law, we've been able to file these lawsuits in just about any federal court across the country. So no matter where you're located, any of our lawyers are able to file a lawsuit for you anywhere in the country, which is important because sometimes people say, well, if your main office is in Florida and you have another office in Massachusetts, how do you file a lawsuit in California? And so that's never been a problem. We've literally filed the lawsuits even as far as Hawaii, many lawsuits there as well. So that's an easy point. Plus, once you file these lawsuits, it's all paperless work anyhow, and the judges rarely ever want to see you in the courtroom. This is a great point for claimants to know. In an ERISA lawsuit, the claimant will never, ever appear in the courtroom. I have never seen it in the thousands of lawsuits that we filed. So there's no testimony from a claimant, so there's no reason for you to ever appear in court, and a judge is never required, as far as on any of our cases, for a claimant to appear in court. So, in terms of the lawsuit being filed, there's no effort whatsoever required on the claimant. So what's the biggest challenge in an ERISA lawsuit against UNUM Insurance Company?
Well, the biggest challenge is going to be really the standard of review, the law that the judge is going to have to apply. The vast majority of states have not banned what are known as discretionary clauses. And because of that, when you do get to court, judges will typically apply what's known as an arbitrary and capricious standard. So that's a matter of the judge is going to review the entire claim file, because after your claim's denied, after the appeal is denied, no new information comes in. It's just this condensed time frame and the information there. So the judge is going to review the whole file. And he's going to make a decision. 2 steps. First, whether or not the judge thinks the person's disabled. If the judge doesn't think there's evidence of disability, that's the end of the case. Now, if a judge does find that there's evidence that would support a medical disability, it goes to a second step. And this second step, when we see case law, is where 99% of insurance company wins kind of come from, because a judge is going to take a look and strip it down to essentially, did they have a reasonable basis to deny the claim? Did they conduct a reasonable review and have that? And in a lot of cases that we see with UNUM, courts will find that just having your file reviewed by a doctor, just the paper, not having you examined, and then UNUM relying on that doctor's report is reasonable enough to uphold, to justify their denial. So it comes down to not this idea of whether or not the insurance company got it right, but rather were they reasonable in their conclusion. And that standard makes it very, I wouldn't say necessarily easy for them, but it definitely gives them a decided advantage when you're already faced with a lawsuit.
Right, so I always tell claimants you're never starting on a level playing field when there's a discretionary clause. And this discretionary clause, which has been banned in about 10 or 15 states around the country for policies issued after a certain date, effectively says we as the insurance company have the right to interpret the terms and conditions of the plan and make a decision on your claim. And because of that, that requires the federal judges to defer to the decision-making of the insurance company. And that's a problem. It's one of the only areas of law where you don't go in where two parties have an equal position, equal ground to stand on. So you're basically going in where the judge is already saying, okay, the law is telling me I have to defer to the insurance company unless I find something that was arbitrary and capricious, which basically means unreasonable that they did, then my hands are tied even if I think that you're disabled. So that's very challenging. Now, that being said, there are lots of cases in which claimants have won, and that's where really good lawyering comes in, to the sense to be able to present to the judge to say, this is why this is unreasonable. These 15 courts have said that the act that this insurance company did or didn't do is unreasonable, and you really have to know, your lawyer must know every single nuance of ERISA, the ERISA regulations, what, for example, UNUM has done in the past, what other courts all around the country, not just in the state where you filed, have done, so that you can convince a judge to say, look, they acted unreasonable. So let's assume, Steve, we're in this ERISA lawsuit and we prove to the court, yes, you know what, our claimant is disabled, the insurance company did act unreasonably. What are the potential remedies that the judge could come down with?
Well, at that point, your first remedy is, you're put back on claim. Back benefits are awarded. The judge can only award a monetary benefit that's owed up to that point, with also the nuances if they denied you during the own occupation period and never did a review as to your inability to do any occupation as defined by the policy, a judge can only go up to that limit. So after that, you're placed back on claim. There is a potential, ERISA has what's known as a prevailing party statute as attorney's fees. So either side, whether it be the insurance company or the plaintiff, if you win, can petition the court for payment of attorney's fees, but it's not a right. It's at the discretion of the court if it's going to be granted, and then the extent of the amount. So that's one of the other remedies that can kind of help. But essentially, you're only entitled to back benefits being put back on claim. There's no guarantee of security or that the insurance company won't do it again in the future. As soon as you're back on claim, it's like if your appeal had been won. New claim forms are coming, new reviews are coming. They're going to require continued evidence of disability going forward at that point.
Right. And then the other thing that the court could do is what's called a remand. And the remand, I think, is a scary tool that unfortunately we see half the decisions come back as. And basically what the judge says is, I think something they did was unreasonable, but I'm going to send it back to the insurance company consistent with my written opinion for you to now reevaluate the claim. So what does that mean? Basically, you kind of might have won the battle and lost the war, because now the judge says, okay, UNUM, it's coming back to you, review it again. Now UNUM does another review consistent with what the judge says, and if they don't approve you at that point in time, you then have to appeal again, and then bring back another lawsuit or attempt to reopen the other lawsuit. Very often the judge will close that lawsuit. That's just a legal technicality. But the point is that you have to go through the whole entire process again. And from what I find is if you get a remand, unless the judge is really critical on saying, you shouldn't have done this, this, and that, basically he's saying, go ahead and pay the person, they're going to now do it the right way. And the claimant gets screwed.
And also, too, if they do it, say, all right, well, Judge, we did exactly what you said, and it still came back that it was, there's not evidence of disability, there's no way a judge is going to find they acted unreasonable because they did exactly what they said. So the remand is a very, very, scary prospect.
The remand's really scary. The thing is that not just UNUM, but many of these insurance companies, fortunately for claimants, are not intelligent enough to review the claim the right way. Even with the judge giving them guidance, they still stick to their old, stubborn, inappropriate, unreasonable ways. And that works potentially as an advantage for the claimant, because you can say, Judge, even though you told them, they still went back to the doctor they've used 100 times. They still didn't do the right review. They did what they wanted to do because they don't care. Because it works for them, they're making money, and we're not going to change it. And that's the battle that we fight every day. So if you have a claim with UNUM, whether it's an appeal, an application, a lawsuit, a lump sum settlement, anything regarding UNUM, feel free to call any of our lawyers. We'll always offer a free consultation. We can help you anywhere in the country, and we look forward to the opportunity to speak with you.